You might think the end of Roe v. Wade, which returned the issue of abortion to the states, marked a pretty conclusive victory for the anti-abortion movement's 50-year legal fight, but you'd be wrong. As legal historian Mary Ziegler makes clear in her new book, Personhood, The New Civil War Over Reproduction, states' rights was never the end game. It was just a stepping stone toward something far more radical and far-reaching, a pseudo-legal doctrine known as fetal personhood. Might sound technical and obscure, but its implications are real and incredibly serious. At its core, fetal personhood says a fetus, even a fertilized egg, is a full constitutional person under the 14th Amendment, which guarantees equal protections under law to all citizens. Last year, the Republican Party approved a party platform that supports states using the 14th Amendment to establish fetal personhood. If that's written into law, it would effectively ban abortion at every stage of pregnancy, and it could have opened the door to criminalizing IVF and further empowering the prosecution of abortion under state criminal codes. And increasingly, that's what we're seeing across the country. Republican lawmakers in at least 10 states have introduced bills that define abortion as homicide. In some states, those laws have led to the prosecution of women who've miscarried, handcuffed just hours after suffering from this health crisis. According to Mary Ziegler, the fetal personhood movement has been quietly taking shape since the 1960s, gaining momentum after Dobbs, but rooted in that earlier era, often in reaction to the civil rights and feminist movements of the time. Back then, constitutional ideas about equality were shifting rapidly. After Brown v. Board and as civil rights lawyers pushed to enforce desegregation, anti-abortion activists developed their own concept of equality, not one rooted in history or systemic injustice, but in vulnerability. They argued that fetuses were America's most marginalized group, not because of discrimination, but because they were weak and voiceless. In their view, this, not race and gender, was the true concern of the Equal Protection Clause of the 14th Amendment. And over the next half century, they adapted fetal personhood to fit the anxieties of each passing era. In the 1980s, amid the tough-on-drugs agenda, fetal personhood was reframed through the lens of criminal law. Anti-abortion leaders described the fetus as a victim of violence, pushing for laws that punished pregnant women for drug use and cast abortion as a crime scene. By the 90s, as support for women's rights grew, the movement worked to soften its image. Leaders began claiming they weren't punishing women, they were protecting them. Anti-abortion leaders rebranded themselves as defenders of both women and fetuses, victims, they said, of a ruthless abortion industry akin to big tobacco. By the early 2000s, the movement tapped into conservative legal networks like the Federalist Society and embraced originalist readings of the Constitution. They took notice when the Supreme Court began recognizing corporations as legal persons. If businesses could be people under the law, the thinking went, why not fetuses? In the 2010s, fetal personhood expanded again, this time co-opting the language of civil rights and religious liberty. It became an all-purpose vessel for conservative grievance, used to claim that Christians were being persecuted, IVF clinics were committing genocide, birth control amounted to state-sponsored murder. But for all its rebranding and strategic pivots, the movement remains deeply unpopular with the American public. Most Americans, even those who identify as pro-life, do not believe that women or their doctors should be jailed for abortion or miscarriage. They don't believe frozen embryos are people. They don't want IVF banned or birth control criminalized. Still, Republican legislators in some states are aggressively pushing fetal personhood bills. Others have proposed abortion trafficking laws, criminalizing women who cross state lines for care by treating the fetus as a trafficked human being. So how has this fringe idea gained so much traction since Dobbs, despite its deep unpopularity? Because the fetal personhood movement has stopped pretending that it actually needs democracy. Instead of persuading the public, the movement is building legal machinery, counting on friendly prosecutors, ideological judges, anti-democratic allies to do what voters won't do. Ultimately, it's betting on 5 sympathetic Supreme Court justices. We see this in Texas, where prosecutors are trying to investigate abortion providers across state lines, not because those cases are likely to win, but because they could reach the Supreme Court. Though Trump mostly avoided talking about abortion on the campaign trail, the legal infrastructure he helped build in his first term is still very much in motion. Most recently, Trump elevated fetal personhood in subtle but telling ways, one of them being his anti-trans executive order, which includes a coded reference to fetal personhood. The order defines a female as, quote, a person belonging at conception to the sex that produces the large reproductive cell, end quote, and a male as, quote, a person belonging at conception to the sex that produces the small reproductive cell, end quote. Aside from the dubiousness of the claim that sex can be determined at conception, Trump's referring to a fetus as a person from conception essentially legitimizes fetal personhood. Anti-abortion activists saw this language as a quiet but significant nod to federal recognition. The House Speaker, Mike Johnson, even praised Trump for declaring, in his words, life as beginning at conception rather than at birth. Critics say it's all part of a broader strategy to push the federal courts toward recognizing fetal rights under the Constitution. The movement's biggest obstacle has always been the American people. But by aligning itself with authoritarian tactics, that's no longer seen as that much of a barrier to their goals, or so they think. As Ziegler notes, quote, it is more important than ever to think through what it means to value life in the womb and for people who are pregnant, and to make sense of whether equality really requires punishment rather than support for the woman carrying a fetal life. That's because regardless of what we mean by personhood and whose rights or humanity it might erase, the truth is that fights over reproduction in the United States are just getting started. And the meaning of equality, well beyond the context of abortion, is on the line. Joining me now, Mary Ziegler, law professor and historian at UC Davis Law School. She's joining me to discuss her critically important new book, Personhood, The New Civil War Over Reproduction. Mary, it's great to have you here. Thank you for being with us. It's grim, the pretext of your book, that we're not even in the final innings of this thing. Explain to me why, if you're already worried, you're already mad about what happened with Dobbs, why should you be yet more worried about this?
Well, I think after Dobbs happened, a lot of when the reporters and other people were talking to me, the assumption was the reason this isn't over is because people who support reproductive rights are going to keep fighting. And that's obviously been true. We've seen it in ballot initiatives. We've seen it in elections. But I think what people misunderstood is that this also isn't over because conservatives haven't reached what they want, which is fetal personhood. That would mean no more ballot initiatives, no more leaving this issue to voters, no more state constitutional litigation. And I don't think people really understood that this is not a new fight. This has been the fight. There is no daylight between the fetal personhood movement and the anti-abortion movement. They are one and the same, and they have been one and the same really since people first started reforming criminal abortion laws in the 1960s.
And one of the things that you track through the 1960s to now is one of the chilling patterns that you trace is how this movement has adapted to the anxieties of each era. Talk to me about what does that reveal about how it views the law and power? It's able to latch on to wherever sentiment happens to be.
Yeah, absolutely. One of the things that's really intriguing about the fetal personhood movement is that people who talk about personhood seem to be absolutely sincere. This is not something where you see people alone in a room saying, oh, actually, this is just about controlling women. That may be something that is motivating people, but this is really a kind of broader thing about how conservatives view equality. And so as debates about equality, about race, about corporate power, as all of those things shifted in the United States, the fetal personhood movement was able to kind of capture conservative sentiment on those things and bring more people into the movement as a result. So this movement's been incredibly adaptable, and there's no reason to think that's going to change, even as though I think we see more internal conflict, right, within the anti-abortion movement about what fetal personhood means than we've ever seen in previous years.
So in the Constitution, there's a lot of things about equality in here, but the 14th Amendment is often what we associate with it. You note in your book that the fetal personhood argument flips the 14th Amendment on its head, using a clause that was meant to remedy systemic discrimination, often thought of on the basis of race or sex, to erase the actual rights of living people. Talk to me a little bit about that.
Yeah, at its inception, people in the fetal personhood movement recognized that they were going to be fundamentally changing how people thought of equality under the law. So the paradigm that the Supreme Court had forged in the 1960s, assumed that when we're looking for a group that's marginalized or that's been pushed to the edges of society, we look for a history of subordination or discrimination, particularly as we saw with formerly enslaved people. And abortion opponents recognized that that wasn't something you could show with respect to fetuses, even on their own account. They argued that fetuses had been cherished historically. So they said, essentially, we don't really need to show a history of subordination. History doesn't really matter to how we think about equality. We care about physical vulnerability. So as you can imagine, if this is the way the Supreme Court is going to think of equality, it's going to have consequences, not just for abortion, not just for IVF, not just potentially for contraception, but for any kind of group that's been pushed to society's margins that's pointing to history to explain what's happening today.
Which is what we saw in that anti-trans executive order. Is that just a coincidence they used that kind of language in the anti-trans order? Or no, you're saying no?
No, absolutely not. I mean, one of the interesting questions, I think, is not whether the Trump administration supports this idea of fetal personhood, but whether the Trump administration is actually going to do anything, right? Whether we're going to see more of these kinds of symbolic gestures while the Trump administration, of course, continues to reshape our justice system and reconfigure our federal courts, or if Trump is going to put his thumb on the scale more immediately in the direction of fetal personhood. And I think no one really seems to know the answer to that in the short term.
Mary, thanks for your history lesson on this and for a great book and for being such a great friend of the show. Mary Ziegler is a law professor and historian at UC Davis Law School, the author of the newly published Personhood, The New Civil War Over Reproduction.